Good morning, everyone. If I'm audible, let me know. So we are audible? Okay. So today's lecture would be technically the beginning of the polity or the constitution. We have discussed about the basic concepts, right? We'll start with the state. Obviously, state, whether it is Indian state or any state, has a political feature. It has a political identity. And this political identity revolves around certain features. So whenever a territory or an entity is called a state, it has some defining features. Most of you might be knowing about the international law definition. Fine. The idea of constitutionalism, okay, rule of law, rule by law, right? Dicey's view, okay, basic concepts that we have talked about, fine. So we'll start with this today. State. So any system, when it is called a state, it has certain features. As international law has to recognize any political territory as a state, then it needs to have certain conditions fulfilled. State is a legal or a formal status which any country or any political territory enjoys with respect to the other nations of the world. It is also a kind of international recognition in the community of nations across the globe. Why it is mandatory? Because unless an entity or a territory has the status of a state, right, it will not be able to conduct its affairs or its interaction with the rest of the world in that manner. And that is why this identity or this idea is important, right? So what features that a state has? Now, when we say use the word, we use a state which is legal, and we use a nation, right, or a country. Now, these two are generally informal terms, right? A country is more related to the territory part. It's more related to territory part. Nation is related to cultural aspect, right? Every nation, every society is different. So the word nation is mostly influenced by the idea of society or culture, right, or civilization. So the civilizational values, whatever be it, culture, aesthetics, art, religion, clothing, language, and many other identities which comes with a civilization will be part of that. Territory is more of a geographical idea, right? So geographical entity. So that gives us more of a country, people living together in a geography. Right? State, on the other hand, is a legal term. This legal recognition is obviously provided by an entity which has already been considered internationally recognized, right? For example, United Nations. So United Nations recognizes under the international law, right? So what do we have under an international law which recognizes the states that fulfill the criteria of that international convention, right? Like, for example, United Nations. These are some universal characteristics. These may be distinct characteristics, right? So these are very distinct characteristics or typical to that particular territory, whereas these are, you can say, the universal characteristics. For example, you need to have a defined territory. All these features must be present simultaneously, right? Not exclusively. It's not that one is there, so it is no. They have to be simultaneously present and not exclusively present. Defined territory, Obviously, your geographical boundary must be defined. Population. This helps us understand technically your citizens versus aliens. Right? They can be both friendly and hostile. So define population. It helps us understand the rights and duties and obligations of a state with respect to its population. Right? Then you have sovereignty. Obviously, sovereignty, as we have talked about, right, will be both internal and external. Then you have rule of law, right? A well-defined justice system, and somewhere a stable government, acceptable form of government, right? So that is also one aspect. It can be generally a democracy or a symbolic monarchy or a presidential form or parliamentary form. It can be any form, but generally the preferred form is democracy. If these features are inter alia, right, along with them, right, they are all inclusive to each other, then you define a state, right? So state in general, which was defined in a more negative manner, right? Normally the state is defined as a system of authority. So somewhere this definition puts one part, authority, only as one of the characteristics of the state, with along with the other aspects, right? So this definition itself creates an obligation on something called the state to serve its people. That is why you have to define population, right, distinctly in this definition, right? So this is like a modern definition of state. In general, as you know, state is a political entity, right? It is the symbol of power in a society, and generally it is born out of a contract, right? Otherwise, we can take state traditionally also emerging from the divine intervention, right? As we have talked about, that states generally reflect the characteristics of society. But there was a time when state was considered to be something born out of divine intervention, monarchical states, right? And they were also kind of legitimate states. But obviously, they did not have the features which are desirable under the international law today, right? So you have this definition. Fine. Then, so state, as per definition, state in general is abstract term. Right? State is a system of authority. It is symbol of entire power. You can use the word authority also, it's okay. Entire power of the society. Right. State is different from government, though for normal purposes we use the term state and government interchangeably, though it is not, right? State comprises of all the entities which are there as part of the system of governance, right? State also includes citizens, no doubt about it. Fine, we have already seen. So state, so they may ask questions like this, okay, state, in the context of India, when we use the word state, right, it is defined under Article 12 and also defined under Article 35 or 36, you can say. 36. Fine. But main definition of the state comes from Article 12. This is done for the provision of fundamental rights. Right? Why defining state becomes important? Because definition of state helps us understand, right, to whom the power belongs. Right? To whom the power belongs and who is responsible for the functions of the society, or who is responsible for governance. So Article 12 that defines the state. Now when you see in the context of India, right, the state is is federal or unitary. It can be federal or unitary the way it governs. It can have different format, right? So Article 12, right? How does it define the state in India? Or technically, what is that state, right? Which constitution tends to define as per the Article 12? What is that state? Union legislature, union executive. One. State legislature and state executive. All forms of local bodies, which obviously includes the administration as well, right? It's not just the executive political part, it's both. So you have union government, state government, local government, right? That's very clear. Then you have any other body. Recognized by the parliament. So any other type of body which may be recognized by the parliament by law, right, will also be the part of state, right? Now these three aspects are quite clear, but this is the discretionary aspect. So question may come that, so clear लिख देते हैं. Question may come that under the definition of state, right, any body, right, apart from the union, state and local government can be declared as a public authority or a state duly recognized by the parliament. So who has the power to recognize any authority as a state or as part of the state? It is parliament. Union legislature, right, not the state. Also, when you say this aspect of defining anybody as part of the state or anybody as time being working as a state, right, it is a kind of discretionary power. So one aspect, union legislature can define it. Second, it is discretionary in nature, right? Can private entities be defined as public authority? Yes, they can be for time being if the parliament makes a law, right? Public-private partnerships, they can come under the definition of state if there is a law which is made, though it has not been done, right? PSUs become part of the state even though they are not technically directly part of the state, but they become part of the state because government has ownership in the PSUs, right? So likewise, they can be, right? This is also very important to define the state. Why it is needed? Obviously to enforce the fundamental rights, right? To make the entities accountable for their actions, right? Then it is also very important to think of these as to implement certain laws, right? There are obligations towards the citizens, like RTI. So when you say RTI defines state, right, or any law particularly talks about the rights or privileges of citizens with respect to the state, then obviously that has to be defined, right? So example like RTI. Now try to understand, we will not be studying in usual way. Why? Because that is the method of the dumps, right? So wherever we need information, we'll keep adding it, and that is how you should remember. Only then you can remember. You cannot remember in one line, in a sequence, right? 1 hota hai, 2 hota hai, 3 hota hai, ऐसे नहीं याद होता है, right? याद करने का method है कि it should be always integrated. So why we have to define? Because there are certain reasons for it, right? Now, see, when you define the state or when you clarify what is the state, right, then you also achieve one more purpose. What is that purpose? An important purpose. No, it will come under law. That is fine. ये तो हमने लिखा है. What is the other benefit? Right? You will also establish the role of judiciary. Right? Now, when you are defining a state in Indian context, obviously you are not using the word judiciary here, right? So why Article 12 now does not include the judiciary? Why does not include judiciary? Now that is a very important question which you should have asked, that why we did not include judiciary in this.
Because
When we take normally the state, right? Think about it. When we take normally a political system, a state, right? We talk about the organs of the state. Even Constitution has defined in detail the organs of the state. So we have legislature, executive, judiciary, right? Why here we have not taken this into account? So let's say a question comes, why Article 12 does not include judiciary in its definition? Because the definition under Article 12, right, is incidental to, it is related to the enforcement of fundamental rights. Against whom you can have the enforcement of fundamental rights? Against those institutions who make laws and implement laws. If you understand it logically, there is a hidden executive power with the legislature also. It can enforce things, right? It sets in motion the no confidence motion. It criticizes the government. It technically reviews the audit report of the government, right? So see, it has executive powers also. So laws, implement laws, make laws, right? Obviously, what kind of function is this? This is a function of authority. What kind of authority? Executive authority. So you have to enforce fundamental rights, obviously, against whom? Against the legislature and the executive both. Article 12 में दोनों है ना भाई. So fundamental right is protected from both. That is legislature as well as executive, right? That is why we use the word कि the laws should not be ultra virus. So the law which is made may negate fundamental right. The one who implements it may also negate fundamental right. So sometimes law may be inconsistent, sometimes the action may be inconsistent. You are getting it protected. So this is important. This is important. They have executive power. Obviously, judiciary does not have executive power, right? See, then there is there must be, or there is inherent idea of judicial review. So it is also quite obvious that we have a provision for judicial review. And this will be obviously done or is possible when judiciary is treated separately from the other organs. So that is why we talk about independence of judiciary. So when state is defined in general, judiciary is part of that. When state is defined specifically with respect to the rights of the citizens, with respect to the obligations of the state, right? And that is why there we don't define judiciary, even though judiciary is also part of the state, right? Now, so judicial review may not be possible if it is part of the state, right? So we use it separately, right? D. Is judiciary involved in policy? No. That is also the reason, right? Judiciary cannot implement, neither can make laws or make policies it does not have the machinery to do it directly, so it does not come under any obligation, right? Whenever it concerns or whenever it relates to fundamental right implementation part, it does not come under any obligation. So it will be illogical to define judiciary under this. We also need an unbiased system to protect our rights, right? So we don't define it, but still state exists or state is defined under Article 12, right? Fine. So state, right, for many other reasons, we have to define the state under Article 12, right? Fundamental right is one of them. Another reason is that whenever there is a conflict between citizen and state, the state has to take up the responsibility, right? Or it may be, the state may be directly trying to intervene into the rights or privacy of the people, right? So for that purpose, we have to demarcate the ideological definition of state from the practical definition of state. That is what Article 12 is. The ideological definition of state will include all of them. The practical definition of state will not include them. For example, Article 300 now. Right, Article 299.
So what about the judiciary's administrative capacity? Will that come in the...
Which administrative? It has administrative functions with respect to its internal system only. It has no administrative function with respect to citizen. Fine. It has to maintain its administrative system within itself. So that is a purely administrative function at the organizational level. Right? When it comes to policy law, that is why we wrote it. No? So policy law, कोई और external function है, judiciary कोई role नहीं, right? Direct. Even administrators are employed under the judiciary, right? First class magistrates, judges, जिनको judge नहीं बोलते उनको magistrate बोला जाता है. They are employed under judiciary. They are performing those administrative tasks. So government has a role with respect to judiciary, right? But judiciary does not have direct role with respect to government. Fine. Executive में judiciary का role नहीं है. Judiciary में executive का role है. Budget बनाना, fine. Infrastructure develop करना. That is there. But judiciary का कोई ऐसा direct role नहीं है. Fine. It is to maintain the sanctity of the judiciary. Article 300 to 99, right? This relates to the tortious liability. Tortious liability of the state, right? That state can be sued and can sue just like a person or an individual. So under what conditions, right? Under civil liability. Right? For criminal liabilities, obviously state is not directly held responsible. For civil liability with respect to any citizen, any group, any entity, any corporate, anything, the state can be sued like ordinary persons or citizens. Fine? That is called tortious liability. Right? For civil wrongdoings of their public servants, right, of their administrators, the state can be sued, right, like any normal organization. So when a mistake is done by, let's say, a bus driver, DTC bus driver, right, he kills someone. Now, obviously, that is a criminal act. There, the responsibility of that individual driver is created, right? But if someone's, let us say, boundary wall gets broken in the process, then it is a civil liability, and state will be held responsible with the driver. That time, the driver will not be treated as independently, right? That is called vicarious liability. Okay, so the employer, ये private के लिए भी use होगा, employer to be liable for the acts of employees. To be liable for the acts of employees. So definition of state provides us with a lot of benefits, lot of limitations also, right? Because when there is one aspect of the state which is not defined, then it creates again a problem that an entity which may not be performing actual state function, like PSUs or banks, they may not be performing exactly state function, right, or sovereign function of the state. They might not, or many times their liability might be reduced, or it must be diluted because of the definition under which they don't fall. So many times these entities have benefits because of the lack of definition. But as many of them are incorporated by a statutory law, by an act of parliament, they automatically become part of the state. Fine. Itna part clear hai? Fine, clear hai, then you write a question. Right, assertion. The definition of state is necessary create its obligation towards the citizens. The definition of state is necessary to create its obligation towards the citizens. The contractual nature of state Right. You know the usual options A, B, C, D. Right. The definition of state is necessary to create its obligation towards the citizen. Statement is correct. Fine. Second statement. The contractual nature of the state makes it mandatory to establish state-citizen relationship. Fine. ये भी correct है. Independently, both are correct. First, that should be established always. That whether these statements are independently correct. Right. Now, is the second statement the reason for the first? Think. Have you thought about it? You tell me, is it correct or not? Correct. Both here are individually true, right? R is the correct explanation of A.
It is talking about the citizen-state relationship, and that is talking about definition of state. तो उसका reason
नहीं तो define करना तो जरूरी है ना. Defining it is important.
Yes, sir.
Why? Because it can create the obligation. Otherwise, how the obligation will be created? Fine. But is definition the only basis of obligation? No. Right. The contractual nature of the state makes it mandatory to establish state-citizen relationship. Contractual nature है, उससे क्या होता है कि state-citizen relationship define हो जाता है. ये independently correct है, ये भी independently correct है. If we are defining it, or if we are establishing a contract, right? We are establishing a contract. So in that contract, what is or why we are establishing the contract? Because there is something which has to be written, something has to be defined. So what is this contract about? This contract is about the nature of relationship. Fine. So if this nature of relationship has to be established, then what is necessary? The definition of the state. So can you put it here and put it there now? You make reason assertion and assertion reason. अब करके देखो. You make the reason assertion and make the assertion reason. वही ये कॉन्ट्रैक्ट बना तब डेफिनेशन की जरूरत पड़ी ना कि डेफिनेशन की जरूरत पड़ी इसलिए कॉन्ट्रैक्ट बना. So it's very logical that you have a contract, the contract defines it, and probably the reason for defining it is what? That the definition of state will create obligation towards the citizen. So इस reason की वजह से ये contract बना. The definition of the state, right, is the reason for the assertion that contract was established to create the obligation or liability of the state or create a state-citizen relationship. How and why this relationship was established? Through technically a definition, or definition of the state was given just for this reason only. तो इसको हम define करेंगे तो ये benefit होगा. दो ऑप्शन जो है सबसे बेस्ट ऑप्शन जो है इसका क्या होगा? A. नहीं, sorry, B. What is B? Sorry, no, C. Both are correct independently. Because there does not seem to be a direct correlation, right? Or at least there is a correlation, but both seem to be an explanation in their own terms, right? दोनों independent explanation लग रहे हैं, right? Not necessarily reason. Okay, लेकिन when you see the final point, you understand कि definition of state कहाँ पे आएगा? Contract में आएगा. तो contract nature of state makes it mandatory to establish state-citizen relationship. ये statement assertion independently ठीक है, right? Definition of state is necessary to create. So इस contract में क्या किया जाता है? Important thing is to define the state. So reason why we are defining the state, right? Or state itself is, or definition of the state is the reason so that we can establish the contract. Reason is not appropriate for the assertion, correct? That is why we are saying both should be treated independently. Fine? Most likely correct होगा. कभी भी बहुत, but ये change हो जाए और ये यहाँ जाए तो more or less correct. Fine? Because these questions are not factual questions. ठीक है, ये factual questions नहीं है. That is why you have to follow a method in these questions. Right? Interchanging the place, first viewing them independently, right? Then finding the basic theme of one statement and the another statement. So if you can add cause-effect relationship to the basic theme, then you can make it correct. So 10 में से, 5 में से, 3 में से, whatever, right? 50% तक correct किए जा सकते हैं, unless obviously you know the facts, right? Unless you have practiced a lot, so you can understand how the UPSC tries to bring these statements. ठीक है, तो उसका भी एक reason होता है, उसका भी एक method होता है कि कैसे tail word end हो रहा है, वहाँ पे tail word वहाँ पे जो बिगिनिंग टर्म है वो कैसे शुरू हो रहा है, यहाँ पे टेल वर्ड कैसे एंड हो रहा है. So always you can do that simple, it's a common sense method, but it may not always be correct. Because sometimes the reasons which are given are highly implied, they are not direct reasons. Right? So it's not like comprehension. Even in comprehension today, they are asking questions which are very implied. Right? Generally, comprehension is done when we look at the comprehension independently, rather than looking at what we know. We just want to read the comprehension and find out what comprehension is saying. मुझे क्या पता उससे कोई मतलब नहीं. But today they are not asking it directly. That is why, again, the problem. So what is mentioned in the comprehension and what you can infer from the comprehension, both are needed now. Right, fine. So let us move. So India mein jo hai, now, when we look at the constitutional structure or scheme of India, right? So we have, like we said, we defined Article 12. Now Article 12 is obviously for the purpose of fundamental rights and others. Okay, Pooja, we'll talk about it now. Don't worry, keep it. Right now, fine, we'll deal with this over a period of time, historical developments. There are some specific questions which are asked from here. Both your history and polity both can deal with it. Right? When you think of modern history, that can also deal with this political developments in India. Right? When you think of polity, that can also deal with it. But the nature of questions will not be, or we cannot distinguish between them. So historical developments will deal over a period of time, don't worry. Jahan jahan zaruri hoga, it's civil services, fine. So we'll deal with the historical developments. In general, when you think of the British impact or the Mughal impact or the previous developments, so the concept of constitution obviously was not created. Right? Mughal administration, did we have concept of constitution? Right? Religious instructions, right? Or theocratic norms, traditions, values, book, जो भी आप बोल सकते हो, and Shariat law, whatever. They had been the basis of the emergence of the legal or political system. Right? Obviously, this was based more on the personal laws. Constitution, even though is a modern concept, the Britain already had its own constitution. So when the colonial rulers come, right, obviously a tradition-based, a religion-based control declined, right? Now try to understand, when we talk about a religion-dominated control, a religion-dominated system, and another system which is mostly based on impersonal laws. Now one system, that is, let's say the British, based on impersonal laws, and this Mughal based on personal laws, right? Which would be superior, which could sustain for a longer period of time? Obviously, this can sustain. So one thing you should understand very clearly, that Britishers, no doubt, whatever they did, they established a system of impersonal legal system. Right? How they acquired the Farman, how they created the factories, right? Ultimately, why did they create a full-fledged legal system, Office of Collector, right? Or the Charter Act, or Regulating Act, Pitts Act, right? And then later Charter Acts, and then Council Act, whatever they did, all that was done obviously first to overcome the influences of these personal laws. Many developments were taking place, no doubt, right? One of the key aspects of obviously the British impact has been the centralization. Very near, I'll take you to very near things like 1919 Act actually dominated the Union government functioning in spite of the 1935 Act. The 1935 Act, which talked about federal system, and 1919 had a centralized feature. In spite of 1935 Act coming, obviously it was never enforced, but still the special provisions for the provinces, for the states, they were there, right? Where they could have enjoyed autonomy with respect to local functions. But then also this dominated the Union government. So Britishers never wanted to leave that power of the Governor General or Viceroy or Secretary of State, whatever you say, right? Even though they were ready or willing to dilute the power of the governor. But in any case, right, in 1935 Act also, when they tried to create a federal system, this can be called as an effort towards decentralization. So 1909 and 1919 Act, where centralization was the key feature, right? Even though they accepted that they are going for political reforms, they did not do it. 1935 Act was a consequence, was a product of the continuous struggle of Gandhi once Gandhi comes to India, 1915, right? And then they initiated this decentralization. In spite of that, they never had intention of decentralization. So union government still dominated. Governor General still had power. Governor General's Executive Council had dominantly nominated members. Right? They were mostly official. There was no political, local, native representation in those bodies. Right? So they were willing to give little autonomy to the provinces, but not to the union level. They did not wanted to accommodate Indians at the union level. Right? Now, so you can understand this logic. Because of these, the conflicts started. This never came into picture. As you know, the princely states were given autonomy not to join it. Obviously, that was creating a threat to the existence of this country itself. Right? They were given a lot of freedom. And they had biasness towards the British government, towards the colonial administration, because they were enjoying almost equivalent status with them. Right? So to overcome this drawback, right, they came up with the India Independence Act 1947, right? Or they established the Constituent Assembly, which again they had to break it into two, and ultimately they had to go for partition, right? So you can say this became the actual basis. This, no doubt, borrowed now many of the features of this act. So when this act comes, the implementation doesn't happen. When this act comes, actually 1990 Act is the act which influences the administration. But when this act comes, right, and when the constitution is created, or when we start making the constitution, this had dominant influence. And that is why we say that 1935 and the previous acts had deep impact on the formation of the new constitution of New India. It's not the Constitution of India, it's the new Constitution of New India, because whatever they had done earlier was a product, was a kind of effort towards making Constitution of colonial India. 1935 भी एक constitution है of colonial India, right? So you can say that way that was created, no doubt, under this Indian Independence Act or creation of Constituent Assembly 1946, right? The effort was not made to make this Constituent Assembly more inclusive in nature, right? There were elites, there were lawyers, there were dominance of caste or people who were higher in the cultural hierarchy. They dominated mostly this composition of Constituent Assembly, fine? नोट्स में होगा पढ़ लेना कितने मेंबर्स थे, कौन क्या थे, कौन नहीं थे, ठीक है? You know, obviously, the around 22 committees were made of the Constituent Assembly, right? 10 related to procedural aspects, 12 related to substantive aspects. So ultimately, right, you can say that the effort to negotiate a constitution of independent India initiated after this act, right? Though 1935 Act was fully visible in the new constitution. Why it happened? Obviously because of two reasons. One, that we wanted, or we were accustomed to, a political system, right? We did not want, we never, or we could not easily break away from that political history. Second, obviously, was that it provided us with a ready-made framework to govern. Even though it was coming from a different culture, different mindset, right? It provided a ready-made administrative framework to govern. For example, All India Services, Union Public Service Commission, right? State civil services, subordinate civil services, provincial system of governing, right? Governor General's Executive Council, this council, that council. Already they were existing. Procedures were already created. So it provided us with a ready-made framework of governance. Right? 1935 Act had a lot of administrative procedures. Already, you know, Macaulay had contributed immensely to the development of the procedures, criminal procedures in India, right? Then prior to that, if you see, there were certain scholars, certain administrators who had contributed to the development of civil services system, right? Especially, any name you know, Hastings created collector's office. Then Hastings' contribution to collector's office. What else? Munro, right? Dominantly civil services reforms, right? So Munro's contribution cannot be denied, right? Then we'll talk about those facts, don't worry, right? So ultimately, the Constituent Assembly, in spite of going through numerous sessions, in spite of formation of 22 committees, right, in spite of looking at various constitutions of the world, it was dominantly influenced by this act. So we cannot say it was a copycat of this act, but it was dominantly inspired by this act because of certain reasons which we have said. It was easy, right? Ready-made framework was there. We were quite accustomed to these systems. Breaking away from the past is not that easy. Right. Fine. So obviously, 2 years, 11 months, 18 days. It took 2 years, 11 months, 18 days, 3 years, you can say, to form the constitution. Right? 26 November 1949, we established, or we had concretized the constitution. 26th January 1950, right? We had already enforced many provisions on 26 November 1949. But many of the organs of the state, many of unique provisions did not come into play or action unless we went for 26 January 1950. So, constitution made, right? Adopted, enacted 26 November 1949, enforced from 26 January 1950. Not all the provisions, some of the provisions. So you can say some were already done and somewhere or rest were done on 26 January 1950. That means now the entire constitution enforced, right? So why the date of 26 January chosen?
Maybe 1928 में वो flag वहाँ पे
29-30 Lahore session, कौन सा session? We had accepted for Poon Swaraj, or we had talked about creating a independent constitution of India, right? Nehru declares Poon Swaraj, correct? 1930, correct. So that is why that date was chosen. Fine. So we had obviously initiated it. Obviously, we cannot say that from 1946 to 1949 there was no government, right? There was a provisional government which was working. 47 to 49 we had a transitional government. Nehru was the prime minister. And you can say that way that the Constituent Assembly itself was functioning in both the ways, as legislature as well as Constituent Assembly. That is why when we say Article 368, right? So Article 368 does not give unfettered powers to the Parliament. The reason was that when the Constituent Assembly was making the law, right, making the provisions, the Parliament of that time was functioning. So when Constituent Assembly and that Parliament, transitional government is taken together, then Constituent Assembly becomes the creator and the Parliament becomes the creation. So for this Parliament, which was a consequence of that law, right, having the same authority, same identity is not possible. So that is why 368 puts restrictions on the Union legislature, that you are not Constituent Assembly. And if you want to act as Constituent Assembly, then you will have to go through a substantial procedure, substantial process. What is that process? You will have to act like the Constituent Assembly. That is why it is treated a distinct amendment, apart from when you see the amendment of the Part 1 or Schedule 1, right, or the formation of territories and states. That amendment is not this amendment. Okay, that is the reason. Because that is purely related to the sovereign power of the state. Fine. But 368 relates to the sovereignty of the Constituent Assembly that created this state. Right? But there are a lot of issues related to that. Obviously, that Constituent Assembly was not made by us, it was created by the Britishers. Right? Does that Constituent Assembly enjoy that sovereignty which we enjoy today, because we have declared ourselves sovereign after that and not before that? Right? So there are a lot of technical issues, but not needed for you, at least in prelims. So we had established the constitution now, enacted the constitution. Obviously, when the constitution was made, right, you know that certain facts, we had how many articles? And everybody is writing everywhere. How many articles were there? 395 articles, right? 8 schedules originally, fine. Then we have 448 right now. Okay. So we have 395 articles, 8 schedules, right? And how many? 8 schedules, 395 articles, correct. How many parts we have today? We have talked about what is a part, what is a schedule, what is article, that we have talked about. 26 तो आज भी नहीं है. How many parts are there? 25 parts. How many parts were there when we started off? 18. 18 or 20? Think about it. It's okay. Right? As of now, how many parts? 25 parts. Okay. 12 schedules, right? 450 plus articles, but there's no title of 400. Right? The title is 395 only. No, you have no 396th article is not there. So you can say the number of articles are 450 plus whatever, right? But the nomenclature of article is not. Nomenclature remains the original. Fine. Okay. Fine. So obviously different parts or different provisions relate to different aspects of the state or Indian polity, right? Now, when you think of part one, schedule one, right? The article 1 to 4, right? What is this dealing with? State. I mean, just now we said state. We discussed the definition, the concept of state, but this is defining the state in concrete terms and how it operates itself, how it identifies itself. See? So when you think of Article 1, you know India, that is Bharat. Shall be the union of states. Fine, you'll get a PDF. Kindly go through the important articles which are given there. You have to remember them. Fine, we don't want to remember on your behalf. We want you to remember them, right? So that you can recall it as and when needed. Right? That is Bharat shall be union of states, right? Keyword union. India, that is Bharat, right? Obviously, there have been various debates regarding this, right? We'll talk about current issues, many things. But let us be very clear about here. When we use the word India, we somewhere think of modernity. When we use word Bharat, we think of tradition. Continuity. Change. In the Constituent Assembly, people had mostly in favor of this, right? But Ambedkar and others, obviously, they realized that this would create a more negative perception of the country in the world, because it might relate more to the sentiments related to a particular community, right? Even though that is not the meaning here, right? Bharat Khand or Bharat world is not derived from a person, but it is related to, yes, the Bharat Khand, the entire territory, the piece of territory which was categorized as the Bharata, the Adi Bharat, right? But obviously, it had included a lot of cultures and diversities together. But as of now, when we say the meaning of Bharat, mostly relates to a particular type of source in history. कहीं भी ऐसा कुछ even though mentioned है, right? History में word Bharat आता है, but that exactly may not be the Bharat we are talking about, right? Modernity and change again represents more liberal values. Obviously, we were going to be a democracy. We had asserted ourselves as democracy, right? And as we were going for a democratic system, right, we believe that we will follow some liberal democratic system. So it is quite obvious that Britishers already had influence, and we wanted to break away from that influence. So the assertion of the term Bharat indicates that. But the term India also somewhere indicates that there is an international presence that we want to establish, not just our identity, but an international presence where India is also treated as one of the countries which have progressive value system. People will give a reference to Indica by Megasthenes, right? But obviously there is no technically evidence whether Indica, what it was written exactly in Indica, right? Bits and pieces are available of Indica, right? But yes, the Greeks used to call us that way, so we can accept that also, right? The word Sindhu, Sindhu to Hindu, and whatever. Fine. Let's say so. That is now. Obviously, politically, this statement becomes little typical because it was very clear that what exactly it wants to establish. Unlike so, Ambedkar was of the view that unlike the America, which was a kind of combination of states coming together, India is not a combination of the independent states or entities coming together. So he wanted to make it outrightly, establish it outrightly, because in US also it was not established on the original constitution. And that is why in the Philadelphia Convention, they had to go for a specific law, right, under which the, or you can say the tendency of different states to move out of or to go out of this collaboration, right, was restricted. So even in US, because it was not mentioned earlier, right, they had to specify that all the participating units which are there, they cannot secede from this association. So keeping that in mind, right, and seeing the Canadian type of model of federation, we are more inspired by the Canadian model, centralized uh, autonomy or centralization decentralization combination works in Canada, right? So seeing that, we went for that kind of idea. So we already wanted to specify that India is no or not a product of many states, independent states coming together. India is a single territory which establishes now its own internal structure through division, right? So that is why they use the word union. So union does not mean it has no federal characteristics, right? So can we say union is unitary? No. Union is not unitary, right? Union is not SR Bombay case, many cases, right? अभी recently जो तमिलनाडु गवर्नर का केस है, right? Lottery के लिए betting and gambling वाला जो law था, right? So it's not unitary, right? It's neither unitary, it's not ideal federal. Right? So people say कि भाई क्या है? तो पहला है कि भाई ये फेडरल है, asymmetric. That means it's federal but asymmetric federal. There are various provisions where you see that union has more powers. There are various provisions where we see they are coordinate, right? So Supreme Court itself has given the view that we are, or even Ambedkar was of the view that we are asymmetric, but state is not subordinate to the union, right? They both are coordinates.
It was more judgment.
No, Ambedkar itself said that we are not referring to the term union in that sense, that states do not have any autonomy, otherwise there would be no list, right? He said that we believe that it is amphibious in character, right? It is, we'll write it, don't worry. The Indian Constitution is sui generis in nature. Right? Sui generis means it is unique and evolving. Right? We can also say that it has amphibious character. Amphibious character, time and circumstance, it can be this, it can be that. Right? So it is not unitary, it is not ideal federal, it is asymmetric federal, it is what you can say coordinates rather than superior and subordinates, one of its own kind, right? Has diverse characteristics. It can be federal and unitary as per time and circumstances, right? Cooperative Federation, Granville Austin. Right? So obviously your first article establishes the name, fine, and technically the nature. Right? Name bhi hai or nature bhi hai. Though you can derive from it, it is not directly stating anything, you have to derive from it, but it indicates that. So you have cooperative federation, right? From here, obviously we start using the terms when we see the features of the constitution, that Indian constitution is cooperative federalism, fine, it is coordinative federalism, right? It is cumulative federalism with unitary bias, federal with unitary bias, or unitary with federal elements. Some scholars have also believed that it is unitary with federal elements or subsidiary federal features. Dominantly unitary with subsidiary federal features, and they have given references for emergency, president's rule, and so many other things, Rajya Sabha status, and likewise. Right? Some have agreed that no, it is federal with unitary bias. So you can assume this way that okay, it has lot of implications of this statement, India, that is Bharat, shall be union of states. When you see the word shall, obviously it means that it will always remain and there is no tendency of its disintegration. In no circumstance it can be disintegrated. Obviously, why? Because the states do not enjoy sovereignty in the first place. The states did not exist when the union was created. The union precedes the formation of states, right? Because when you say that okay, India had acquired certain territories, those were princely states, right? But they were technically not states. They were not provinces. They were categorized under the 1935 Act as a different territory, territory A, B, C. So उस definition में है ही नहीं कि वो state है. भाई वो तो territories थी. We have acquired the territories, right? So Article 1 and Article 2 gives us this power. We shall be union, right? And Article 2 says we can acquire territories which are already not part of the state. So you can acquire external territories, you can create a new state, right? You can create or acquire a territory and create that into a new state. And likewise, that is what? The external acquisition of external territories are not existing territories, but which are already a state. For example, princely state, right? For example, Arunachal, Mizoram, Goa, whatever. Yes, they were already technically a state. So if we acquire them, right, it is now our sovereign power to do so. So Article 1 establishes the name and the nature. Article 2 establishes that sovereignty over its own territory. Own territory or acquired territory. Right? So 2 is more related to what? Now, the classification of the territory, right? In which there can be different types of territory. 2 and 3 have little difference. 2 defines our types of territory. Right? We'll talk about, don't worry. First, you see, so nature of Indian polity or Indian political system, its functioning, right, may move beyond these features, right? So we can say that yes, it is federal. Now, when you see SR Bombay case, right, or 370 judgment, right, where the Supreme Court has said that internal sovereignty does not belong to Jammu and Kashmir, right? Neither external sovereignty, because the moment it has given or signed the instrument of accession, that very moment it has given us its sovereignty. That is correct, that okay, the sovereign functions of telecom, border roads, defense was to be performed by India. So obviously that is also logical that in relation to the Jammu and Kashmir, we were already performing sovereign functions. So how can it ask for sovereignty from us when we were the one protecting its sovereignty? You can imagine this way. If I'm protecting your sovereignty, then obviously I'm much more sovereign than you. So it becomes illogical, right? Territorial integrity is not visible in Indian constitution or is not specifically clear in Indian constitution regarding the states or the territories of the state. There is no territorial integrity available to the states or any internal territory, right? We'll talk about it. See, so you have this typical character. So we can say that it is more of cooperative federal, right? It is federal with unitary features, right? And likewise. So you can get a question that, okay, out of all four, which of this uniquely defines the Indian polity or nature of Indian political structure? Right? Sometimes it may seem that all of them are correct. So put, if the option is there, federal with unitary bias, क्योंकि ये सब क्या है? ये सब opinions हैं, facts नहीं हैं. Quasi federal opinion, cooperative federation opinion, right? Supreme Court कहता है federal है तो federal है, as simple as that. Federal of its own type. So we should neither say quasi federal, right? Nor we say federal with unitary bias. Let us say it is federal of its own kind as per the Supreme Court.
In the case as we talked about the reality of the states, so all the states which are in India, they don't have external sovereignty.
They don't have. They don't even have internal sovereignty.
But even by the Jammu Kashmir, the other would have internal sovereignty.
How can there be internal sovereignty?
For example, for states like northeastern states.
No. When the principle will be applied, it will be applied to all. Right? How can we apply specific principles to specific? Right? For example, right? See, when you say that there are certain states which have special status, fifth schedule, sixth schedule, 371, 370, they have special status, right? Who recognizes this special status? The union government. Right? What is the basis of that special status? Is it territorial integrity? No. Right? Development needs, regional problems, right? Some other cultural issues, cultural distinctiveness. So what is the basis of how it is legitimate to have its own constitution? Who said? 370 is a wider political discussion, right? We have to understand it that way. So whenever you are saying that special states, right, the special status is not given, right, on the basis or the format of association. It is given on the basis of their specific needs. So politically, whenever special status is given to any territory, it is not treated distinct from us. It is only treated distinct for specific purpose. The entire territory per se is not treated distinct. पहले ये समझ लो. तो politically उसका कोई status नहीं है, right? Socially है, economically है, culturally है. That is the reason. Fine. Jammu and Kashmir, like we said, constitution, but it was obviously established by that arrangement, right? That it can have its own constitution for transitional purpose. It was not a permanent constitution. First, understand that it was done for transitional purposes so that the trust factor can be established. And certain provisions were integrated in that constitution just to make sure that this territory was, first of all, quite vulnerable. Secondly, it was very distinct from the rest of the country. Thirdly, it was very close to the proximity of hostile neighbor. So it was agreed upon by Nehru and others, obviously, that the typical or you having a kind of special document or your constitution should be guaranteed only for the transitional purpose, not for absolute control, absolute function. That constitution was not permanent constitution. Right? So many of the laws which were to be enacted by parliament would be enacted by them, would be approved by the assembly. Most of the times it was approved. They had no option to say no. Right? We were already controlling the defense and so many other things. Right? Secondly, because we said there is dominant population of a particular community, and that is why they should be given some freedom, right? So that to protect and preserve the sanctity of that contract which was made by that, right? But you see, the moment you sign a contract or access or what you can say, document of accession, that very moment Article 3, Article 2 comes into picture, right? You become the part of Article 1. अगर जम्मू कश्मीर स्टेट भी नहीं है, यूनियन टेरिटरी भी नहीं है, तो क्या है? तो बहुत बड़ा क्वेश्चन मार्क है ना भाई. हमारे यहाँ तो ये टेरिटरीज है ना. But this is how we have defined in the constitution, right? Your union territory or your state territory, right, or any other territory acquired by the union or the government or state over a period of time. So what kind of territory you are? Are you annexed territory? We did not annex you. You came to us, right? In that ground, on that ground also we have the sovereign power over you. Right? You are already a state, yes. Maybe you are existing as a state. We took you under our fold, right? Then automatically Article 3 again comes into picture. Or 2 and 3 both come into picture. Right? So the moment you agreed to join us, right, you are aware of all the conditions which are there. So idea was कि भाई, see, can you go back to your own sovereignty in future? That was not clear, never written. Right? So that is one dilemma. So how it can have its legitimate constitution, but purely which follows the principles of association between them and us. So when we say it is integral part of India, yes, it is, because there was nothing else existing then. Right?
Introducing the Prelims Target course and Prelims test series at ProdEgyIAS. Designed for UPSC Prelims 2026, this comprehensive program offers in-depth classes on history, geography, science and tech, environment, polity and governance, and economy. Stay updated with current affairs and sharpen your skills with our Prelims test series consisting of 50 full-length tests covering all subjects along with CSAT. Join ProdEgyIAS and stay ahead.